So under Hawaiian Kingdom law, people have a right to worship in any way they see fit, so long as it doesn't violate the rights of others. Now, this right of worship is protected under the Hague Convention, okay? The laws of occupation. So on Mauna Kea, for people who see Mauna Kea as a religious site, Hawaiian law protects that right to worship, right? But it doesn't exclude those who may not see Mauna Kea as a religious site. They may not, right? But the law of occupation protects the right of people, not certain people. So if certain people claim that it is a place of worship, others who don't recognize that cannot say otherwise. So in order to get away from the debate on this issue of who's religious and who's not, under Hawaiian Kingdom law, what is very important is what is called Native Tennant Rights. So Native Tennant Rights, which is a condition of the property, right? So specifically in 1848, the Hawaiian legislature passed a law accepting certain lands given to the government by Kamehameha III, the king, as government lands, which included the ahupua of Kaohe. It specifically stated that these lands are subject to the rights of tenants. Now, the rights of native tenants are not specifically addressing worship, but rather it would include worship. It would also include access, gathering. These subject rights of native tenants have been codified under Hawaiian Kingdom law. In fact, it is a part of deeds that are recorded on all lands throughout Hawaii. It's a condition of the title, right? So the native Hawaiians that have been on Mauna Kea in resisting that first attempt to construct the 30-meter telescope have a vested right in that land. And as a person or persons with that vested right, I would say they have a duty to ensure that that land is not destroyed. Now, whether they do it through religion, they do it through cultural practice, or they do it by mere resistance, it's considered native tenant rights. And that's important. And that's codified under Hawaiian Kingdom law, where it says that native tenants have a vested right in all the lands of Hawaii. It's called an undivided right. But that undivided right in the land does not mean ownership. It actually, it's beneath the ownership, right? Or the control of the property. These vested rights are defined as rights that are so secured they can only be transferred by those who have a vested right. A third party cannot convey somebody else's rights. And that was clearly articulated in a Hawaiian Kingdom court case in the 1850s called Kekieke versus Edward Dennis. And the court, Hawaii Supreme Court, said, not even the king could alienate the rights of native tenants because he cannot grant the title any more than he would have, subject to these rights. So these are important elements of Hawaiian Kingdom law that are unique to the Hawaiian Kingdom. We're looking at transition. How do we transition to comply and to ultimately end the occupation? What is so important here in our particular case is that the governmental infrastructure of the state of Hawaii is actually from the Hawaiian Kingdom era. All that happened in 1893 was a change of the executive monarch and her cabinet, and Marshal Charles Wilson as the head of the police force. Everyone in government, in these agencies, were told to continue in place, just sign an oath of allegiance to the new regime, which was illegal. The point I'm making, though, is it's that infrastructure that still exists today. So the transition, when the occupation ultimately comes to an end, it's really just taking back control of the administrating power of the United States, which is our governmental structure. This does not require the United States to create an entity. That entity was already created under our laws. We're just continuing where it was left off.